right, everybody. It's the big morning. So, here is what's going to happen. I'm doing a couple of things as I get ready, because these guys are going to come out fast. Whew! Hope you guys are excited. And I know, like, I'm going to say this several times today, that when these cases come out, there's good news for people and there's bad news for people. And you sort of have to accept, any moment, they should start. Actually, they may have already started. And so excitement is relative. Hold on, a moment. They should start. Actually, they may have already started. And so excitement is relative. Hold on, I need to put... Bad Benny, I'm sorry to hear that. I didn't sleep great either, but I think it's just because I find that if I, it sounds ridiculous, but if I think too much during one day, I have trouble sleeping that night. Okay, all right, I'm getting to it. Court. Let's see here. Opinions of the court. Let's see what we got. All right, oh, CASA. CASA, they started with CASA. Okay, what are we going to say? CASA's our big one, in my opinion. Applications for partial stays are granted, but only to the extent that the injunctions are broader than necessary to provide complete relief to each plaintiff withstanding to sue. That's not great news. Maybe. This might be... Okay. They say that they may exceed the equitable authority that Congress has given to federal courts. The court grants the government's applications for a partial stay of the injunctions entered below, but only to the extent that the injunctions are broader than necessary to provide complete relief to the plaintiffs. Ooh. Don't love this, guys. The problem is that I'm going to have to read this one really closely to get an answer. By the way, will you guys hit like a bunch of times? We only have 2 likes, so it's warning me that nobody's going to come in. Thank you. Thank you very much. So, here's the deal. I'm going to keep my eye on the docket, and we will come back to this. Don't panic. Let's see what it says. We're going to go through it. And I want to give it enough time. I want to give it the time that it's due, rather than just give you guys a quick answer. Let's look at it slowly, but these other ones are going to be coming out. Let's keep an eye on those, and we'll come back and do it nice and slowly. I will do definitely going to do a regular video in this case. It may or may not, I don't know if it's going to, depending on how extensive it is, because it's a 119-page opinion. It may be a tomorrow thing, if it takes me a while to get it all read and properly done. But we're going to give it its proper time and make sure it's answered fully. So we have our answer in CASA. They are granting the government some part of their stay that they requested. Oh, let me go ahead and start downloading these into the folder so you guys can read them. I mean, you can obviously find them yourselves too, but if you want to. SCOTUS June 27 opinions. I am surprised, but I was kind of thinking about this last night and wondered with the whether equity would factor into this. So that is actually, it sounds like the direction that they went, and the fact that it is congressionally controlled. So historically, they have always deferred to Congress, and the question, I guess, that they're going with is whether or not Congress gave them the equitable power. So we're going to give that a full look before we decide what it says, okay? And with these other ones coming out, I don't want to miss everything else. Nothing else is out here yet, so we're going to spend another minute here on this guy. So they're saying, okay, for those of you equitable. By the way, yeah, can you guys hit like for me? Equity and law are two different things. For those of you who don't know, and law has very strict rules. That's what I'm talking about right now. Psychedelic views. Law has very strict rules, and is like all the things you can get in law are usually money. This is civil law, by the way. So all of the remedies in law are generally money. Equity is like a different area of law, and it used to be a totally different court. And it's where the laws are more flowy, touchy-feely, and the remedies that you get are also more flowy, touchy-feely, but they're harder to get into. And injunctions, telling people to do or not do something, are equitable remedies. That's something that happens in equity. And today, thank you very much. I've got my coffee. Thank you. I forgot. I meant to have the names ready so I could thank the people who sent me coffee, but thank you. Decisions in equity they're kind of a different animal, and they come from a different theory. I did a whole video, a very long video on the history of equity. It goes back to like the 1200s, and it's its own animal. But it is more difficult to get into because it's got more power to it. And so what they're saying here is that that the lower courts have restricted authority in equity. And they're supposed to, because law is supposed to be where you do most stuff because it's more formalized and more predictable. Equity is where only certain situations end up, and it's harder to get into, but it gives the judge a lot more flexibility. Equity or injunctions, preliminary injunctions, things like this are all in equity, and they're saying that the lower courts may have gone a little bit broader than they should have in exercising these injunctions in equity. Now, again, this is a 119-page opinion. I don't want to tell you guys what it says until I have a chance to spend what is probably going to be a lot of hours reading this thing. And then I promise to give you a real answer on what it says. So we have we have our first result. Let's see if we have a second result yet. No, that's the only one we got so far. Okay, so whether Congress has granted federal courts authority to universally enjoin the enforcement of an executive order warrants this court's review. On multiple occasions and across administrations, the Solicitor General has asked the court to consider the propriety of this expansive remedy. As the number of universal injunctions has increased over the years, so has the importance of this issue. Oh, you guys. Hold on. They may not have actually decided this. This might be a temporary stay. Application for partial stays granted. Is that a stay on the... See, this is the problem with this case, is I can't tell whether... yes, it could be a lot more complex than that. It's 119 pages. It's gonna be complex. And that's the problem, guys. You're gonna see easy answers. The news is going to tell you what the answer is. And in the end, some of them might be right. But let's give it time before we do this. Let's read it properly. And one thing that I'm wondering here is that, so this is an application for a partial stay, which I did not realize before, and I paid a lot of attention to this, so I somehow missed that. Let me see. So, okay, so these were applications for stays on individual cases. And I'm processing this real fast in my brain here, guys. But the government was saying, hey, these lower courts enjoined the entire government in these three cases. We want the Supreme Court to pause those three injunctions until those cases have a chance to make it through appeal. Because we don't think that the... I don't trust ChatGPT. ChatGPT does not do a very good job. It will give you answers that aren't correct. And so those basically it wants them to pause those three, and they've granted those partial pauses to some extent. I am not sure whether it's saying more broadly that this is not about birthright citizenship. This is the birthright citizenship case, but it does not change the rules of birthright citizenship. It was the first one they dropped, which kind of surprised me. Speaking of, I need to go back and keep checking. Again, guys, this is a 119-page case. Nobody will have time to read this in more than a couple of hours. So anybody who tells you what it's about birthright citizenship, still fine. Anybody who tells you what it's about in the next 15 minutes is not telling you the truth. 1443 I-1 removal. I cannot tell you about that because I don't have that on pause in my head. I apologize. Thank you. I appreciate that. So let's breathe. This isn't necessarily, it could be bad news. It could be good news, but we got to break it down properly first. And I'm checking to make sure that nothing new has come out on the docket. I'm hitting refresh and even hitting this again to make sure they didn't release anything else. They have not. They've only released Trump v. Casa. So let's see here. Neither the universal injunction nor any analogous form of relief was available. Oh, they're going back to... Okay, so this is what they are going to do, is go back and look... Ooh, that is questionable. Okay. They're going back into... Okay. If you guys have not watched my video on equity and you want to understand what's going on here, I recommend finding it. It's in my Civics 101 playlist, but it's one of the older ones. And it starts with me saying something like, there is a 1,000-year-old court in America, something or other. Go watch that. Watch the whole thing. It's not my best work because it was early on in my process while I was still learning. And understand the history of the equity court. And they're going to go through the whole history of the equity court here because that's what they're doing. They're going back here and looking at... What year are we looking at here? Because we are looking at old school equity. High Court of Chancery. The equity offered mechanism for the Crown. The original English equity. So we're looking at old school equity to determine whether this was a remedy available under original equity. So we're going to go back, way back. Without this injunction, could feds move a citizen to a location where there is no stay and rendition? I don't know. I have to look. There are so many different cases going on right now that it's hard to keep track of all of them. And this is specific. So the irony of all of this, and the thing that... This is the problem, is that I don't think that the government realizes what they've done here. Because they're hurting themselves in a lot of ways, because they are also limiting their own ability to do things. Because if they release these three, then what they're saying here is that it only releases these three. It doesn't release anything else because they're limiting the power of these things. So I don't know. We'll see. But again, I need to read this whole 119 pages before I might as well go ahead and print the damn thing. All right. I got a vote for the room. Casa's a big one. Casa's my biggest one. What do you think? Is it yellow, pink, blue, or green? That's what I got available right now. Yellow, pink, blue, or green. Morning. Oh, it's a day. Pink. We got pink. We got one for pink, one for blue, two for pink, three for pink. Or pink, I'm seeing mostly pink, guys. I think this is going to be pink. All right, we're going to go pink. Don't worry, there will be more options. So, ooh, I need to add some white because I think this is going to be a long one. So, I always do the first page in a color. I used to do the whole thing in a color, and then I started doing the first and last page in a color, and then I realized I just need the first one. I think you shirt influenced us. Did I? I'll tell you in a second about this whole shirt situation. After I get this in here and then check and make sure that we don't have anything else coming out. Give me one sec. Let me get this printing because I'm gonna need it. Go ahead and do give me one sec, guys. I'm not looking at the moment. I will be over in a moment. Too big. And double-sided on the short edge. Okay. Let that print. Okay. Let's see if we've got anything else come out. Still nothing. Really? Does anybody else see? Is nothing else going out? Okay. All right. So real fast, let me tell you. Have I been studying Newspeak? I have not read that book since I was a kid. I got a heart. Thank you. It's from Penelope too. Okay, so somebody said something about the shirt. I have never owned an Aloha shirt in my life. I always hated them. And then I went to... I'm so glad you're here, Penelope. You caught me. I went to American Samoa, and I was an assistant attorney general there. And my uniform, essentially, was this, and what they called an ie whaitanga, which is a skirt. Every day, it's a skirt. The kind of informal ie is just like a piece of cloth that you tie. An ie whaitanga is what we call... Are you picking up your Venmos? I am definitely picking up I'm living on my Venmos. Yes, thank you. Thank you very much, Craig. And then the whaitanga is like a more formal looking one with pockets. And so that's what I would wear to work. And so I'd wear this skirt to work every day, and I'd wear it to court, and wear flip-flops to court. And on Fridays, I would wear this and this beaded necklace. It was a formal beaded necklace, which would essentially fill in for a tie in court. And the rest of the week, I would wear a white shirt and tie in court. But don't say that word. Don't mention other applications at all. Okay, got it. Sorry. I apparently can't say that word. Okay. Do we think the conservative majority is doing this because they don't see a return to democracy? No, I don't. I think that the conservative majority is making decisions based on pretty classic conservative ideology. And by the way, conservative judicial ideology mostly. It is not that different from what you usually see. When you look at the way that they interpret, it's pretty classic conservative interpretation. And I missed a bunch of stuff here. I'm trying to catch it. Did they just limit nationwide injunctions only to the plaintiffs, or what? So that's a very good question. I'm going to have to read all 119 pages of this to find out for sure. This timeline is kind of bleak. Yes, it is. I'm really shocked that the courts would do this to themselves. But, okay, so here's what I'm going to say about the courts doing this to themselves. And again, with the really big caveat. Bring me back to conservative judicial ideology in a second. With the really huge caveat that historically, every single time that the court has interpreted their own power, well, not their own power, but the power of the lower courts related to Congress, every time they have deferred to Congress. Every single time. Because Congress has the total power to decide whether or not we have lower courts. And so the Supreme Court, time after time, says Congress can just wipe out this whole court system. So whatever they want to say, they can do. I was surprised to see this because it felt a little different, but what they're saying here, I believe, and again, I haven't read it enough yet to know, and it's 119 pages. We don't know the answer yet. Nobody knows the answer yet. If somebody is telling you on the news what it says, they don't know. They have either ChatGPT'd it, which is absolutely unreliable, or skimmed it and made a quick decision. Either they're wrong or they got lucky. But what it looks like, real quick, and let's see if I get lucky, is that they said when Congress gave us these powers, they seem to have been limited beyond what we're doing right in this area in equity. So that's what they said. Yeah, they made a decision, but they did make a decision, but nobody's had time to read it. It's 119 pages, and it's super complicated. So nobody's had time to read this enough to know what's going on. And I'm looking at it, and it's all about the history of equity. I happen to be I'm going to go ahead. I'm kind of an expert in equity. As lawyers go, I know more about equity than most lawyers, the history of equity in particular. And I'm looking at it and kind of know what they're talking about. Nobody else does. If you want to read it, go to my link tree. It's, I think this will do it. Hold on. I wrote this yesterday, and now it's, I have to do it backwards so that it's readable. It's also in my profile. Sorry, the right colors aren't here anymore. So I had to write it backwards so that you could read it. I think that's right. If you go there, there is a folder. There's something that's like the third or fourth thing down that's called Shared Documents. You go there. You don't have to accept the cookies. And you can open it in browser, and it's just one of the folders in the list. It's very simple. It's just it's just a Dropbox link. Will be June 27th SCOTUS documents or something like that. And it's the only one I've got in there so far because it's the only one they've released so far today. Unless I am wrong, we're going to hit refresh again. So I said this yesterday. I'm going to show you guys this, okay? This, I hope, doesn't look weird, but... oh, God. Let's see if I can do this. This is really tough to do. Okay, I'm sorry. That's not going to work. Oh, how about this? This might work. Hold on. Sorry, guys. Yeah, all right. I'm just going to end up making you all sick. I apologize. There's all of my stuff on my wall. See? Looks so nice and organized back here, and over there it's just a mess. What I was going to show you is that if you look at the Supreme Court website, like their list of opinions, it'll say it has an R number, and then a date, docket number, and then the name of the case. And on a day when they're releasing a bunch of stuff, the R number will be empty until they're done releasing. And when they're done releasing, that's when they'll all fill in all at once. So you'll see like nothing, 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 and then they'll all fill in. That means they're not releasing anything else. So, yeah, I was looking for the camera flip, and I didn't see it. You would think it'd be right here. I think it's inside of another window. There's so many... I don't know if any of you have ever gone live before, but there are 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19 different buttons that I can push, and none of them say flip, but a couple of them say like more and other things, so it's probably in there somewhere. So yeah, I'm really kind of surprised that we're at 10:30 and they still only released this one case, because they I like that. I kind of was expecting more from this. Oh, will you guys hit like for me, because we're still a little low for the number of people we've got in here. Yeah, we're still sitting at that one case. So for those of you who just walked in, let me fill you in. We have Trump v. Casa, which is the birthright citizenship case. It is not about birthright citizenship. It's about whether or not the lower courts can enjoin the entire government. The court did allow the stay, which is what was granted, to pause those lower court injunctions until they get into a higher court, based on the as far as they go beyond the required. They're allowed to the people who are in. Sorry. So, from what I've read, from what I can tell so far, and it's 119 pages. I don't know everything yet. The injunctions are there to protect the plaintiffs in the case, right? And the injunctions are still allowed to protect the plaintiffs in those cases. So if you're a plaintiff in the case and the lower court has issued an injunction to protect you, then you are still protected. But if you're not a plaintiff in the case, then you may not be protected. But we're going to see, I'm going to do a better read on it, which is going to take time, and it's going to be hard to do while I'm talking. And it is, at the moment, from what I can see, this is a stay on those 3 cases. I don't know yet whether it will affect other injunctions. I need to read the whole thing. And I think that's a really hugely important question that I would want to make sure that I had a really good answer on before I answered it for you. All right, there's our next case. Okay, what do we got? Kennedy and Braidwood. Okay, this is the other big one. This is the other biggest one. So, oh, please be written by... I thought this was going to be written by Kagan or Kennedy. Let's see. Oh, dear. It's written by Kavanaugh. That's not great. Okay. Well, oh, wait. So the issue here is whether or not it's who gets appointed to the board that determines what medications are covered must be covered, and particularly preventative medications. So the question is whether HIV medications must be covered. Okay, good. All right. Sorry, I didn't see who else was on it. I kind of panicked when I saw Kavanaugh wrote it because I was expecting it to be Kagan or Jackson. So that's good. Let me get this saved into the file for you so you can get to it if you want it. Again, if you guys want this, it's right here. I know it looks weird, but I had to write it in reverse because my camera is flipping everything, so I had to write it backwards. If you go there, there's a folder of, okay, good, Alito, Thomas, and Gorsuch dissent. Woo! All right. I'll look at it in a second. So you guys can download that for yourself. It's in my shared documents, Kennedy v. Braidwood. So the question is here, this is about, essentially the important thing here is about HIV medication, not HIV medications, but HIV preventative medications. There's a lot of people who are on PrEP. Those of you who do not know this, okay, those of you who do not know this, there's something called PrEP or Truvada, or now there's other versions of it. They are essentially, yes, we did do CASA, I'll come back to it in a second. Truvada is a daily pill. They're now coming out with shots that are like every 3 months. I think they may have come out with one that's every 6 months, and essentially are vaccines against HIV. PrEP, which has been out since the early 2000s, if you take the pill every single day, your odds, your ability to contract HIV is dropped almost to zero. So it's an incredibly important medication, and it is essentially, it's got a huge impact on stopping new HIV infections in the United States. So the question is whether insurance will be required to continue paying for it because of religious objections by some insurance companies. And if it's expensive, so if they don't have to pay for it, they're all going to say they have a religious objection. So let's see here. But the question here was who is on the task force. That was the actual question. But of course, if that changed, it would probably determine who was going to determine it. So the plaintiffs were small businesses who object to the Affordable Care Act's preventive services coverage requirements, and they sued in federal court. Braidwood Management argued that task force members are principal officers under the appointment clause who must be appointed by the president with advice and consent of the Senate, not the secretary. The district court agreed, and so it would have changed who was on the court, who was on this task force. Held, task force members are inferior officers whose appointments by the Secretary of Health and Human Services is consistent with the appointments clause. So they don't have to change who's on it. They don't have to change what's covered, I think, is going to be the end result. This is one of those things where the result and the question weren't necessarily in line, but the implications were big. So, again, even the syllabus of this is like 6 pages long. But, let's see here. But it really is all about who is the appointment clause question. So it's a little bit hard to say. Okay, so let's go back to urgency equals validation. I don't know what that. All right. So we're going to go back, and somebody just asked me about CASA. So let's talk about CASA. What we know, or what I know. And, you know, as somebody pointed out, yeah, I could have run this through ChatGPT, but I have run enough things through ChatGPT and gotten answers that weren't correct that I don't do that. So, essentially what it looks like on a quick read is that these, at the moment, these were applications for a stay of these lower court orders. The stays have been granted, but only to the extent that they still protect the plaintiffs in these cases. They may not protect people beyond those plaintiffs. I don't love that, and I'm kind of surprised by it. The part that I'm not surprised by is that this has nothing to do with other people not having. This did not change birthright citizenship at all. This was only this really didn't change birthright citizenship. This was a procedural issue only. One of the underlying cases was about birthright citizenship, but it's not there yet. Oh, okay, sorry. And it's really going into the history of equity here. The part of this that didn't surprise me is that, and I think I said this yesterday, but oops, sorry. The Constitution. Woo, sorry, my little thingy here kind of. Let's move you. Nope, wrong way. Back over here. The Constitution, Article 3, creates the Supreme Court. And they're like, these are the guys that are going to handle court stuff. And if we need any other courts, Congress can set them up. That's what the Constitution says. So the Supreme Court, they are stable. They're not going anywhere. The other courts are basically set up at Congress's discretion. And so Congress has a lot of power to say, like, for example, there is if you want to sue in federal court over money, it has to be a certain amount of money, because Congress has set a minimum amount of money that you have to be talking about before it gets into federal court. And so Congress is allowed to do that. And the Supreme Court has consistently validated restrictions on the lower courts that Congress has set, because Congress has very strong control over those lower courts. And so that's essentially what they're saying here, is that they looked at the way that Congress had set these courts up and said that they thought they might be stepping past. Again, I'm still guessing because I haven't read all 119 pages, and this is one that needs to be read. But that they stepped past what Congress had laid out as the edges of their power a little bit. So we're going to look. We're going to see. I'm lost. Does that mean there won't be class action lawsuits? I don't know yet. Until I read this, I won't know. I'm still talking to you guys. Again, I don't mean to, talk garbage about anybody else, but nobody's read this yet. It's been 40 minutes. Maybe somebody's gotten a good read through, but it's how limited is this ruling big picture wise? like I said, I don't know. I've only been able to look at a couple of pages of it. This one needs a full page by page, every single word read through before I tell you guys, because they're going into all this history of equity and the chancellors and everything. And you got to read it. Oh, new case. All right, let's see what we got. Which one we got? We got the two that I was most... Okay, FCC. So this one is about the woke... I just get... When I hear that word... I know that we are not all of the same political stripe. And I understand that. But there are some words that are just poorly marketed words. That one just has... I don't love it. All right, so this is FCC v. Consumers Research. Here's the deal with this one. There's a part of the FCC that pays, it's a federal program that pays for low-income, I think phone bills, but definitely high-speed internet. They go around and they pay for high-speed internet. And yeah, it's as bad as saying moist. This organization whose primary goal is to attack woke corporations, that's their deal, has decided that this is a woke corporation that they need to shut down, because bringing high-speed broadband to rural areas is woke. Okay. Again, policy. And so they are fighting... but the exciting thing is that they're fighting based on the non-delegation doctrine. And those of you who have talked to me, I love the non-delegation doctrine. Non-delegation doctrine was this old doctrine that said, okay, we've got our 3 branches of government, and each of them has their own list of powers, their own things they're supposed to do, and not only are they supposed to not steal other people's powers, they got to stick to their own powers, but they're also not allowed to give away their powers to anybody else. Non-delegation. They're not allowed to delegate any of their powers to another branch. The walls between the branches are sacrosanct. And this was an early idea. It came from, I want to say Montesquieu. It was one of those like late 1600s or mid 1600s Enlightenment guys. Like all of the guys that, all the like the philosophers of the late 1600s, the people who wrote our Constitution, these were their rock stars. Montesquieu and Locke and all these guys from the that era were like a big deal. It'd been like 100 years, but they were still pretty big deal. So anyway, this non-delegation doctrine is a really big deal, and it lasted for a while, and then very slowly they started coming up with examples where they would allow things to cross the line, like math. Like they would say, okay, we're going to set up a law, but the math has to be, like we're going to say that this has to be done, but it's like based on a math problem, and we don't feel like writing a new law every month to recalculate the math. So we're going to let the president calculate the math. That was Congress. And so they started with numbers, and then it got bigger and bigger and bigger, and eventually we started having agencies and stuff like that. So non-delegation doctrine is very old. It's not really used anymore, but it does kind of keep some stuff in its lane, and it has us narrowly read things when they cross those lines. This is arguments based on the non-delegation doctrine. They said that the FCC crossed the border and wasn't allowed. And here it says the Universal Service Contribution Scheme does not violate the non-delegation doctrine. So, okay. I am going to read this in detail, but I don't think it's going to get people very excited. Other than me, I will probably still make a video about it, but it'll probably be like Sunday or Monday because by the time I get to it, it'll be more for me than it will be for you, is my guess. And these videos, I don't know if you guys have noticed, but they take me a really long time. I am hoping at some point to be able to speed this up, but it takes a while. So the internet stays. Internet stays. Yeah, these guys did not violate their power. Michelle, so Michelle said that, and she said something. So she said George W. Bush and Mitch McConnell, what was the word you used? Designed this court. Okay. And I would like to say it's set up for presidents to be able to set up the court over time. And the adult site ruling did not come out yet. That is Paxton. I think that we're down to 3. So it is supposed to be, if you have conservative presidents for a very long period of time, president after president after president, the court is going to slowly become conservative. That's how it's designed, and it's supposed to be a slow thing. If you want to take over the court, you have to elect one president after another, after another, after another, and it keeps you from being able to make fast changes at the court. That is part of the design of our system. Whether or not we like it, that is how that part of the system is designed. But there's a very important caveat here, which is that Mitch McConnell broke the rules. When he did not allow what's his name's the name is escaping me all of a sudden, Merrick Garland's nomination to go through, that was a violation. I think that was, I will not ever forgive him for that one. That was a violation of the rules, and he has been on my bad list ever since. That is one thing that he can never outlive by my standards. There are a lot of things that are good or bad, but within the rules, and that was not one of them. You would have to tell me what you're talking about, Ken Fandango. It's another decision. All right, which one we got now? Excuse me. Okay, so it's Mahmoud v. Taylor. Okay, so this is, I'm pretty sure I know how this one's gonna go. This is the one in Montgomery County, right outside of DC. And it's whether or not children in school parents should be allowed to opt out of the LGBTQ plus inclusive story hour based on religion. And I'm almost positive that they will be allowed to do that. Alito delivered the opinion of the court. So, without an injunction, the parents will continue to suffer an unconstitutional burden on their religious exercise. Yeah, that was not a surprise. Okay, I'm going to show you guys something real fast. Oh, please don't screw this up. Okay. Sorry. Now, I'm going to save Mahmoud. Yeah, Mahmoud was not as exciting to me because I figured that's the way it was going to go, and usually, well, whatever. Okay, so I will come back to your question about breaking the rules. Hold on. But let me show you guys something real fast. I explained this, but let me show you this because anytime that the Supreme Court dumps a bunch of cases like this, this is what this is what I wanted to do, and this is why I didn't do it. But let me see here. I know it's here somewhere. Oh, come on. You are right here. Sorry, guys. Maybe? All right, no, we're going to have to do it the hard way. I am on YouTube as well. It's in my link tree. Okay, so Can you guys see? This is what the thing looks like. And there's nothing in these boxes. These were the cases that were released yesterday, so they have our numbers. And there's nothing in these boxes, which tells you that they are still releasing cases. Okay? As soon as these are all filled, and it'll just have like one more case will get released and all these numbers will be filled, that means they're done releasing cases for the day. So that's how you know the Supreme Court is not releasing any more cases today. Okay? So that's just a little bit of inside baseball that is very useful to have if you're watching these. Okay, let me see here. Okay, breaking the rules. So what Mitch McConnell did is say, so we were in, what was it? It was February, I think. February, March, something. Anyway, it was sometime. And Mitch McConnell said that a president is not allowed to nominate a new Supreme Court justice in his last year. And therefore, the entire Senate would not allow a hearing on a new Supreme Court justice. That had never been done before. I'm not certain whether there had been any other nominations in that time period or not. But a couple of years later, when there was a Supreme Court nomination in the last 2 months of a presidential term, they did confirm. Same Senate. So it was not okay, and it's had huge implications on a lot of stuff. Does the court ruling change the laws of the Constitution? Can you explain your question? Which court ruling and what are you talking about? Wasn't that the rule since Lincoln? I don't believe it was. If it was, they certainly didn't keep it up, and I have not heard that before. It was. I don't think it was the rule since Lincoln. But if it was, then they did not stick to it, a month or a couple of years later. So, let's see here. I'm on YouTube as well. I am, and once again, if you go here, which apparently I'm not allowed to say out loud, it's my I shouldn't say the YT thing either. It's on there as well. So you can also find ways to support me. If you guys want to support me, please do, because I am running on support. This is what I'm doing right now, because I have not been able to find another job that I can do while I do this. I am working and researching kind of all day to do this stuff. So I'm trying to survive doing this. So I would really appreciate the support. And okay, let's see. I think there's too much that I've missed. Justices throw shade at each other. Oh, yes, they do. Can I talk about injunctions? Yes. Hold on one second. I will actually also run through everything again. But let me just make sure that we haven't gotten anything new. We have not. Everything, by the way, also is here in my shared documents if you guys want to download them. Note the dot there. And I know it looks weird. It's backwards because this camera flips everything. So I had to write in reverse, which is not easy to do. Okay. Injunctions are a form of equitable relief. Equitable relief is not legal relief. Law and equity are two different animals, and I do have a video on the Court of Equity, which I recommend watching. It's fun. It's interesting stuff. I actually love equity. Is fascinating, but equity allows a judge a lot more flexibility. Instead of just following laws very precisely, it's much more, what's the best outcome here? And so injunctive relief is an equitable relief, and it allows for a temporary hold while the court case reaches its natural conclusion. And the idea behind it is that court cases take a long time, and we don't want... We want the process of going through a court case to end with the just outcome as much as possible. A meritorious, just outcome, right? Good morning. And if the court case itself can become a weapon because it takes 2 or 3 years, and a person can use that 2 or 3 years to get what they wanted anyway, whether they deserve to win or not. I'm getting into what an injunction means. Then we're not going for a meritorious or just end. So, for example, let's say my neighbor wants to build... that's not good. My neighbor's building a mine under my house. If they continue to build the mine, my house is going to collapse. So I sue them to stop them from building the mine. If it's going to take them 2 years to get through the court case, then by the time we get to the end of the 2 years, my house is going to have already collapsed. They're going to have gotten their mine dug anyway, and so they're going to have what they want, and I'm going to be screwed, right? The damage will have already occurred. So, an injunction allows the court to weigh what's going on and decide to tell somebody to do or not do something in the meantime while the case is going on in order to prevent damage. And it keeps people from using that 2 to 3 year time period as a weapon in order to get what they want anyway, even if they weren't going to win the case. So like one of the first requirements of an injunction is that you have to be more likely to win the case than not. So if you are if the legal basis for your case, if the people who are digging the mine have absolutely no legal basis, like they don't own the land that they're digging it in, there's zero chance of them winning, then, and they try to file to enjoin so that they can keep digging, there's no way they're going to win, because there's no way they're going to give them the injunction and let them keep digging, because they don't have a right to dig in the first place. They're probably not going to win the case anyway. If I don't actually own the house, similarly, they're probably not going to let me argue that my house is going to get damaged because it's not mine. That one might not be great. Anyway, so they have these it's usually about 4 different things that have to get checked off. And if all 4 of them get checked off, then they will put in an injunction. And a couple of them are weighing things. They're like, does this person get damaged more than that person? What's the best outcome for society? They go through, and those are kind of equitable things. There's a lot of weighing things in equity. So that's what an injunction is. It stops things temporarily in order to prevent more damage. Well, it could be blocking. It tells somebody to do something or not to do something. But it is very limited. A court's power to enjoin or not, or to enjoin somebody is very limited, because the powers in equity are limited. And so there is a difference between law and equity. And this is part of equity. They used to be 2 different courts, like literally 2 different buildings. And then when we got into, and in some states they still are. Delaware still has 2 of them. I think Mississippi has 2 different ones. In federal court, they've always been the same, but you do have to let them, this is filed in equity, this whatever, and they use different words sometimes. So basically, Trump can do what he wants now without oversight. Okay, so I have not had time to read this case yet. It is 119 pages, and it's going to be complicated. So until I have a chance to sit down, and it's going to take me hours to read this entire thing, because I read slowly and thoroughly. And I usually, if it references a case, sometimes I go and read that case too. I like to make sure I really know what's going on. Before I answer these kind of broad questions, I want to know what the answer is. I want to tell you guys the real answer. And, I'm sure other people, by now it's been an hour, I'm sure some people actually have had a chance to sit and read it at least thoroughly enough to give you a real answer. Half an hour ago when people were telling you what happened, no. They had either chat GPT'd it, which is not reasonable. Did they have, I don't have an answer to Paxton yet, unless I'm hitting refresh and there's nothing there. I want to see Paxton, and I want to show you guys something. Can I ask you a really sensitive question? Yes. Ask me the sensitive question. I'm going to look for something real fast. Nope, that's not what I want. Sorry, guys. So ask me the sensitive question. Give me a moment, because I want to try to find something real fast. I did want to show you guys something. What I really wanted to do, I realized as I was walking back from picking up coffee this morning, again, I don't usually go out and buy coffee. I usually make my own, but I decided I deserve a treat this morning. Oh, thank you guys. Yeah, will you hit like? Everybody hit like for me a couple of times. I've seen you say California Viva Vertata like 6 times. I'm very sorry. There's a lot happening. I'm going to write it. Hopefully I won't remember to look at that. And I'm also going to refresh this real fast. So there's something I really wanted to get up here and draw on the whiteboard before I got started, so I could show it to you. But I didn't have time because the line was really long. Can you explain what the decision of birthright citizenship means? Okay. So I'm going to come back. Give me a few minutes, and I will come back to the question about Trump v. Casa for both of you, because I just finished doing it once. I'll do it again in a minute, but give me a second. That's the birthright citizenship question, which, by the way, is not about birthright citizenship at all. It has nothing to do with birthright citizenship, but I will come back to it in a second, okay? Come here. Sorry, guys. Before we get Paxton, there is something that I wanted to have up on the board and ready to show you, and I didn't have a chance to get it written. I don't know if I'm going to have a chance, because it could pop up any second. It might be too late, but... I did Kennedy v. Braidwood. I'll do it again in a couple of minutes. Let me just try to find... No, it's not there. Was it Parrish? No. Oh. All right, there's one. Sorry, guys. Just a moment. I'm almost back. I'm just trying to find something. Can you go over each of the decisions? Yes, I will. I'll keep going through them. Just give me 1 second. I'm trying to find something so that I can run you guys through before Paxton comes out. I have something that I really want to show you, if I can get it done. If I can get it out. I think it was in... Maybe? Nope, not that. But we're getting close. Okay. Thank you for hitting like, guys. I appreciate it. I am just looking for this dot thing. Your additional background. Oh, thank you very much. Yeah, law is very technical. Is limiting federal judge injunction as bad as it sounds? Maybe. But we'll get there in a second. Ah, there we go. That's what I was looking for. Okay. Can I... What is the best way? Trying to figure out the best way to show this to you. It's going to take me like 10 minutes to draw it up on the board. I don't want to do that. Let's see. All right, I have an idea. Come on, internet. Did it come out yet? DM with a law review. Okay, all right. Oh. Let's see. No, let me. I'm sorry, guys. Give me one more. I'm really close. I think. Janice, under sensitive question? Oh, yeah, I don't think I saw the sensitive question yet either. Okay. This is not being cooperative. All right, I'm going to have to do this in the fastest way that I can, which is I have a color printer, but it is not in here, and so we're going to do this, and we're going to do it in black and white, which is not as great. And this one. Oh, this is driving me nuts. Sorry, guys. Subject videos. All right, we made that way harder than we needed to, and I apologize. Let's see if I missed anything in the meantime while I was trying to do that. Probably Paxton came out in the meantime, and I didn't. Okay, fortunately nothing came out while I was doing all that. I apologize. So, All right, let's see if we can even, hopefully you guys can see this. So, birthright ruling came out with a caveat. Okay, yes, it definitely does not rule on the merits of birthright citizenship. It was not supposed to rule on the merits of birthright citizenship. That's not what it was about at all. It was going to be about the ability of equitable remedies by the lower court to enjoin the entire federal government. And I am confused and surprised, but it seems like they have limited the ability to do that, but I don't know for sure, and I need to read the case first. It's a long, long case, and I don't want to tell you what it says until I've read it. So that was a quick read. I'm sure there's going to be a bunch of people, but I will break it down fully so you guys can understand it a little better, but that's probably a quick read. Okay. Oh, and it's in reverse. Oh, that's even worse. All of that, and you're not even going to be able to read it. Damn it. Hold on. Any chance that I can somehow mirror? I don't think I can. Can I flip it? I'm trying to see. Let's see if there's... Okay, so here's what I'm going to try to do here, guys. This is kind of funny. All right. Here's what we're going to do. Oh, very close up. Hi. I'm going to see... because I want to run you through this real quick. Come on, you were just here. Where'd you go? No. Flip camera. All right. Okay, here we go. All right, so I want to run you through a couple of things that are important here. Sorry about the mess in the background. Now, and it's correct, right? You can read this, I hope. So Paxton is going to be a First Amendment case. That's what we're going to be talking about. And the issue is going to be the correct standard of review. Here's how a standard of review question goes. It is a sentence, okay? It's a grammatical, normal sentence. What we say is that the law passes the standard of review. The law is allowed to continue operating if the law is rationally related to a legitimate government objective or interest. That is called weak or rational basis review. That is the lowest level of review. And these are the levels that the Supreme Court applies to violations of the Constitution, or so if a law comes before them or a government action comes before them and they're trying to decide, does this violate the Constitution? This is usually how they will decide. But the first thing they have to decide is whether this particular violation gets this level of review, this level of review, or this level of review. And generally, this level of review almost always passes. This level of review very rarely passes. Okay? So let's go through these sentences real quick. If it's weak, or what they call rational basis review, then the law must be rationally related to a legitimate government purpose. So our purpose was to stop people from dying in car accidents, and so we required them to wear seatbelts. Okay? Is that law, the law requiring them to wear let's say that the interest is, the objective is to stop them from dying in car accidents because they're flying out of their seats. So that's the connection. So is that law? Yeah, that law is it's rational to relate that to that government interest. And is it legitimate? Yeah, generally kind of anything is legitimate. That's not a tough thing to get over. Okay? Okay, so for intermediate scrutiny, which is these two are called heightened scrutiny. These are like the higher levels. The law has to substantially serve an important government objective or interest. So, is the thing they're trying to serve, is the objective they're trying to get to, is it important? So first we'll answer that question, and then we'll say, well, does it serve that purpose? Like, does it actually do something about it? Like, by making them put on seatbelts, does it actually do something? And then, how much does it do something? Is it substantial, or is it just a little bit? If it substantially serves an important government purpose, then it passes intermediate scrutiny. And then finally, you have strict scrutiny. This is the toughest one, which means that the law is necessary, as in there's not an alternative. This is the only option. It's necessary to achieve. It can't just serve it. It can't kind of do it. It has to achieve it. And it has to be a compelling government interest. This has to be something that really, really gets people. Okay? So these are the three levels. Okay? Now, we're going to look at how this plays out in First Amendment cases. And I hope the new one hasn't come out. I have not been watching your stuff because I've been kind of looking at this screen. Okay. And then this is how it goes in the First Amendment. And this is what we're going to deal with in Paxton. Okay, so be prepared for this. This is what we're going to be talking about. Is the government involved? Is the Constitution involved? This is generally, if the government and the Constitution are involved, this is actually a bigger question for which of the three do we do, weak, intermediate, or strict scrutiny. We push over into these higher levels if there's a fundamental right or suspect classification. The First Amendment is a fundamental right. So generally, if the First Amendment is involved, we push over into either intermediate scrutiny or strict scrutiny, one of those two. And if it is a First Amendment case, then we look at whether it is content neutral or content based. Did you restrict people based on their content? Did you say, whatever your restriction is, did it separate people based on what they were saying or what they were thinking or anything like that, on the content of what they were saying? If it's content neutral, if it applies to everybody no matter what they're saying, then they get intermediate scrutiny. If it is content based, then they get strict scrutiny. So if it's something that says like no protests after 10 p.m., that kind of generally applies to everybody. If they're just like, protests have to end at 10 p.m., people got to sleep. Okay. If it says no Republican protests after 10 p.m., well, that's based on the content. So that's going to get strict scrutiny. It's not that you can never say no Republican protests after 10 p.m., but if you're going to say that, then you're going to have to demonstrate that that law is necessary to achieve a compelling government objective for some reason. And I'm not saying you never will, but you very rarely are going to be able to pull that off. So that is a quick overview of the standards of review and the First Amendment, and we're going to need to know that in a few minutes, maybe already, we'll see. And I'm going to get real close, sorry. And we will lower that back down. Okay. So, hope that was worth all that looking. I'm sorry but I think that was worth seeing. And let's see if we have any more cases. So that's going to be important for Paxton because, which just came out. Okay, so let's see Paxton. And I will save Paxton into the folder. Let's see here. Free Speech Coalition Coalition v. Paxton. So the question in Paxton, this was about requiring age verification to use, I probably can't say this on here, so P-Hub, if you know what that is. And when they evaluated this, they did it using rational basis, that lowest level of review, which usually, if it's First Amendment, it should have either been intermediate or strict. So lowest level of review, which usually, if it's First Amendment, it should have either been intermediate or strict. So the fact that they used rational basis, is this a First Amendment case? And that's the question. So let's see what they said. It survives under intermediate scrutiny, but it is subject to intermediate scrutiny. So this was a First Amendment case. It was not tried as a First Amendment case the first time, but it was a First Amendment case. But they say that they must have said that it is content neutral, which is interesting because it's definitely based on content. The First Amendment leaves undisturbed states' traditional power to prevent minors from accessing speech that is obscene from their perspective. And this is the thing is, I feel like preventing minors from accessing pornography would have been acceptable under either of those tests, right? Oh, can you guys hit like, by the way? So I'm kind of surprised. I think it would have survived strict. This is one of those rare cases that I think would have survived strict scrutiny. And I would have seen them, but I don't know. So applying the more demanding standard of strict scrutiny, here we go, would call into question all age verification requirements, even long-standing in-person requirements. Oh, interesting. So they're saying that if they were to require strict scrutiny here, that it would also apply to lots of other things. Hold on. Let's see. Go back to Tom. Sorry, guys. I know I missed some things, and it's hard to see this in the little window. I can only see like 2 or 3 lines at a time. I'm trying to find Tom's question, but I don't see it. Doesn't this drastically change how EOs can affect the country? You're talking about, yes, it does. I mean, or it could. It could. I don't know. We're going to have to, like I said, the problem with this case is that it's 119 pages, and I've been talking to you guys since it came out. So I haven't had a chance to sit down and read every single page of it. It's going to take me 5 or 6 hours to read. And that one, I don't think I can scan through. Some of these other ones, I can scan through and tell you what's in them. That one, I've looked at a few pages of it. It's going to require some nuance. Do you think you'll have a video out today after you read? I'll have a video out. I don't know if I'll have 5 videos out. By the way, if you can see, if anybody looks at the website, you'll see that those numbers, those R numbers are added now. So that is all they're putting out today, which means 1, 2, 3, 4, 5. They have not released every case. So we still do not have, who don't we have? Calais. Interesting. So that is the one case that we are still waiting on is Calais, which is the question of whether Louisiana's political boundaries were racial boundaries. Deferred to next year. Okay. All right. Interesting. Oh. Okay. All right. Well, that's an interesting choice. Okay. Well, that's weird. I'm surprised because that seems like it would have been. Okay. Well. So let me show you. I tend to print these cases in order to save paper. I print them 2 pages at a time, which makes them kind of slow to read, and double-sided, except for the first page, so I can see what it is. And still, this CASA case is massive. I don't know how many pages this is, but I'm not even sure I can staple this. So this is going to take me a while to read, and until I get all the way through it, I'm not going to be 100% certain on exactly what the implications are. I will tell you that the stays were granted, except as far as they applied to the plaintiffs in those cases. So the injunctions in those cases said, yep, my stapler will not staple that case. The injunctions in those cases said, I'm just thinking here, these plaintiffs cannot be sent to Guatemala. The injunction also said the administration cannot send anyone to Guatemala. If I read this correctly, and I am not certain that I did yet, these cases are stayed, those injunctions are stayed as far as enjoining the rest of the government, which I see as a bit problematic, but I'm not wearing a robe, and my opinion only goes so far. I need some decisions here from you guys in a moment. So, I used pink for CASA. Oh, did I not get a good copy of... Oh, whoops. I did not get a good copy of Paxton, so hold on. Let me get a new copy of Paxton saved in there. Hit like. If anybody wants to help me out, there are ways to help me out here. And, you can also subscribe here, I think. In here. I have subscribers in TikTok. But there are other things you can do here, and there are copies of all of these cases in my shared documents on this folder, and any cases that I ever talk about are usually put in my shared documents. At some point I probably need to come up with a better shared document system, but for right now this is what I have. So that's it. It's also in my profile if you want to find it. If you go to my profile, this will be the link at the bottom of my profile. So, and it's got a bunch of ways to, I just found out that I can't say the name of other websites in here, so I have to be careful. But there are Amazon and Vinmeux and some other things that you can do if you want to help me keep doing this, because I need ways to be able to keep doing this and not, lose my house. Oh, right, okay. So, did I get a better copy of... No, why does it keep doing that? All right, well, what I'm going to have to do... Maybe I'll try printing it as a PDF and see if that works. For some reason, Paxton doesn't want to save. So we'll try putting it in there as a PDF. See if that works. Not working? Yeah. Okay, so Paxton is our free speech case, and I need a color. We're going either blue, yellow, or green. I need a call. So let me know, blue, yellow, or green. This is just a straw poll. Just rated my live as educational, useful, and informative. Thank you very much. All right, I see blue, green. I see a couple greens, a yellow, blue, 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 green. So far the blues are winning, but let's see. I'll give it one more second. Blue. All right, I'm going blue. So Paxton's going blue. And somebody just refilled all my colored paper, which is great because I needed that. I was running low, but I am good on colored paper at the moment, and that's very helpful. Let's see here. I'm going to do the cover page first. Right. You have amazing talent and support. So, thank you about the talent, and I do have great support. You guys have been very helpful. So this was all just a whim for a little while I was gonna change careers, and I'm still here because I've had enough support that I'm able to keep doing this so far. It's, just enough, so, but, I'm still alive, and by, keeping things together, I've been able to keep doing this. So I had to take like a little break for a little while because I started to get a little behind, but we can't class action sue the government. So I would be surprised if you can't sue as a class action, because the whole argument in, that's pretty. The whole argument in the CASA case was that class actions were the correct way to do this. That was the government's whole argument. So I'd be surprised if you cannot sue by class action. That was the government's argument, was that the alternative was class action. So that would surprise me. But until I give it like the solid read that it needs, I'm not gonna know. Let's see. Ooh. Let me see here. All right, let's see here. Come on. Sorry guys, I'm just printing out the rest of Paxton. Make sure I got that right. 110. So I can get to work on these. All right, so let's see here. What did I miss in my questions here? Okay, so let me run back through what we have so far. If you guys were, is that what you want to hear? I forgot. I think I was supposed to go through these again, and I don't know if I have. All right, let me run through these again. So first, I'll do it in reverse because it's here. Paxton, and I did a breakdown of the standards of review and how First Amendment cases usually break down. The first time Paxton was tried, it was essentially tried not as a First Amendment case. It was tried under rational basis review, which is not what you do for a fundamental right. And a fundamental right is a right. There's a slightly broader answer than this, but generally it's a right that's written in here, right? That's written in the Constitution. If a right is written in the Constitution, it is a fundamental right, and it requires some heightened level of review, either intermediate or strict scrutiny. So they agree that they should have given it a heightened level of review. So they did, and they say that the law still passes because it does. And they say that it doesn't need strict scrutiny because in this case, lots of things require age verification, and like they said, in-person things require age verification, and if everything that required age verification required strict scrutiny, that would be a bad result or something. Again, I didn't read it closely enough to... That is probably not exactly the answer, but one way or another, that has something to do with why they decided not to do strict scrutiny, but I'm pretty sure it still would have passed strict scrutiny, which is rare, but in the case of preventing children from having access to pornography, I feel like that is one of those things where they probably could have gotten away with it. But it definitely passed intermediate scrutiny. So that is Paxton. Mahmoud is... Mahmoud was in Montgomery County, Maryland, which is just outside of D.C. They have a LGBTQ plus story time in school, and some parents wanted to take their children out for that one event. And there was no option for them to do that, and the court said you need to have an option for them to do that if it's based on their religion. So that's that. So that's Mahmoud. FCC v. Consumer Research. I'm going to need to read closer. Ooh, thank you. I'm going to need to read closer because generally the way it was presented and the way I've thought about it up until now was whether or not this program was going to continue. Oh, wait, never mind. I'm sorry. I'm flipping topics. FCC was related to this organization or this program in the government that provides money for rural high-speed broadband, and this organization, non-government organization who fights woke corporations, did not feel that that was a good use of money or something, and said that it violated the non-delegation doctrine. And the court said, no, it did not violate the non-delegation doctrine. I'm going to make a more in-depth video about that because I love the non-delegation doctrine. And it's like one of my favorites. So I will definitely make a more in-depth video about that, but probably, especially since nobody else loves the non-delegation doctrine as much as I do, because it's super obscure, probably one of those things that I'll do, next week or later this weekend or something when I'm kind of out of other higher priority things to do. So that's FCC. Braidwood. Now, Braidwood is the one that I need to get some more detail on because I need to make sure that I'm understanding all of the implications. How do I feel about the decision so far? Mixed. Very mixed. Mixed, but unclear because a couple of these are very long and I need to read them properly. Congress needs to stop farming out their work to the executive branch. So I'm not against farming out the work to the executive branch because there's too much work. The problem is ensuring that there are that everybody's doing the parts of the work that they're supposed to be doing, and I'm not sure that that's still happening. My understanding and my view of this has always been that. These a lot of these agencies are created by Congress, and the executive branch is there to do things like make sure that there's enough paper, make sure that there's an HR department that's doing the payroll, not set policy for everybody and tell them what they are and aren't allowed to do in their jobs. And I understand that some of these agencies are in this world between the executive and legislative, but I think that those lines need to get defined a little better. And the executive is there to execute. The legislature is there to set policy. And we need to clarify whether or not the president is supposed to be setting policy in these groups or not. But whatever. In California, we have a private attorney general doctrine. Does this doctrine? Can you tell me what the private attorney general doctrine means exactly? And I have a guess, but let me know before I respond. Okay. So back to Braidwood. Braidwood is the question about there's a group of people set up under the ACA. Oh, wait, hold on. Wolf of the Year, yes, I do see you. But by the way, guys, I can only see about 2 lines of this at once. So even if it's mostly if I happen to catch you while I'm not looking away or off talking. Any lawyer can bring charges and prosecute. Huh. Interesting. I have to think that through. Judges make law all the time, but it is a little bit different. And it's, it's funny. I think my understanding of case law has evolved a lot over the past 6 months as I have really, really focused on really on answering questions. I kind of had an understanding of this from being a lawyer and kind of understanding, what I needed to understand, but so many people asked me to clarify things, and I was like, well, I need to make sure that I really understand what I'm talking about before I clarify. And so I started doing more and more research and really clarified in my own mind where the lines were. There is a really distinct line between law as it's written by legislators and law as it's written by a judge. They both have the effect of law, but they come from very different places. But that's a whole other speech. Okay, so Braidwood. Basically, it was the question that I understood out of it was whether or not these guys were going to be required to continue providing HIV meds or HIV prevention meds, and I'm not sure what the answer is, because what I'm hearing is coming out of the news is a very different read than my quick read, which is why I try not to do a quick read and give an answer. So I'm going to need to do a deeper read on that and make sure that I have the right answer. So here would be what my question is. The issue is that there is a group of people whose job it is to decide what medications, what preventative medications insurance companies are required to provide. And there's this group of people. This is their job. And some people in the government have to go through this process where they are appointed by the president and then approved by the Senate. The question here appears to have been, do these people need to have gone through that process or not? And the answer seems to be no. These guys do not need to have gone through that process. But the challengers, the challengers of this seem to have been people who did not want to pay for HIV preventative medications, who appear to have lost. So I'm a little unclear, but also it sort of looks like that would allow the current administration to replace everybody on the board, unless they have 6-year terms or something like that they can't be fired. I don't know. So until I get into all of that, it's going to be a little unclear whether or not RFK can go in and just replace them all tomorrow. And they can just decide that HIV preventative meds are no longer covered by insurance, which would be a public health disaster, because HIV preventative meds since have made a huge difference. For those of you who don't know, HIV preventative meds like PrEP, Truvada, that came out in the early 2000s, it's a daily pill that essentially reduces HIV transmission to something less than, it's something around like 1 to 3%, I think. The likelihood, it's lower than using a prophylactic latex. I don't want to use a word, I don't know if it'll get flagged. So they're incredibly effective, and so they've really cut down on the transmission numbers in the United States. And now they've come out with these shots that you can get that are every 3 months, or I think they've now come out with one that's every 6 months. So it's a huge deal, and so but they're expensive. And so if they stop covering that, that would be a big problem. Would Biden have been able to implement student loan forgiveness if Trump v. CASA happened before? Maybe. I would have to, yeah, probably. But again, no, you know what? I shouldn't answer that yet. Maybe. I'll say maybe, and until I give a good read, I don't want to answer that. But it's possible. Yeah. If the big beautiful bill was passed, when might it take place? 2026. It's for next year. And yeah, HIV preventative meds are not, I'm not sure. Having a religious objection to something that saves that many lives seems problematic. But certainly wasn't in any religious text that I've ever read. Let's see here. Okay. But again, well, I'd say that's outside of my wheelhouse, but I did kind of major in ancient philosophy, so, well, fine. Ancient literature and language, but you read a lot of philosophy. And then the last one is, of course, the big one, which is Trump v. CASA. Trump v. CASA, again, nothing to do with, nothing to do with birthright citizenship, but it is not a birthright citizenship case. One of the cases involved did involve birthright citizenship. This is not a birthright citizenship case. But I'm going to give it a good solid read and get you guys a much better answer, so that we have a good answer. And let's see what. I'm going to stay about 12 more minutes so I get to 2 hours. But and then we're going to wait for, I guess they pushed back the Louisiana v. Calais case for to the next term. So we will hear that one next term. Let's see. Yes, you did finish. All right. We have that. We have that. So there's Paxton, ready to go. You gonna do a live on Trump v. CASA or a video? I'll definitely do a video. I don't know if I'll do a live because it's so long. I'm going to be like, here's what me reading CASA is going to be. It's going to be like 5 or 6 hours of me moving from room to room around my house, around being on the front porch, like trying to change spaces, carrying around a giant stack of pens and highlighters, and trying to come up with get through everything because it's going to be so long. What are your preliminary thoughts? My preliminary thoughts are that they have stayed these preliminary injunctions and questioned whether they go beyond the equitable powers, but I don't know whether they truly have made a definitive statement on whether equitable powers can be used in the future, or whether they said in these particular cases they are stayed. Let me take another look here and see what. So they're saying the. I'm just looking here. We're going to talk about bills of peace, which, oh God, we are getting into some old Well, so one thing is that the executive branch is not allowed to do anything for 30 days. So that's key. The stays are granted only to the extent that the injunctions are broader than necessary to provide complete relief to each plaintiff withstanding to sue. So this is the problem, is that what does complete relief mean? And this is where I really need to give this a... Ooh, oh, that one's cool. This is where I need to give this a really deep read, because complete relief is an interesting question. Oh, and of course Trump, I mean, of course he's interpreting this the way he wants to interpret it. That's what he does. He's also not a lawyer. Complete relief, and this has been my question all along, is that complete relief is relative. And how do you provide complete relief to somebody if I can just think, there's so many examples that are kind of bubbling around in my head where relief could not be given to an individual plaintiff without enjoining the rest of the government. So I am just not sure what this means and how this is going to play out, and I'm going to have, like I said, I'm going to have to read every single page of this probably several times before I have an answer. And that's why I don't want to go too far about saying, CC, do you agree with me on this? I think that's why I'm holding my tongue. I want, I see some stuff in there that I just don't see as a clear answer. And that's just a quick review, but okay, thank you. I'm glad to see that, because sometimes, I'm like, am I missing? But and so I do think this is going to restrict the power of the lower courts a little bit, or somewhat. But in this case, this one's just a little funky, and I see this. This is definitely one of those ones that's going to lead to some appeals court splits. And of course, the administration is going to claim victory, because they always claim victory. What's you've heard the thing about playing chess with a pigeon. So that's just what's going to happen. So individual plaintiff is granted citizenship, and that doesn't change if others are not, but it might, because if the rights of, say, family members are impacted, or the ability to use state facilities is somehow impacted, or extra paperwork is required. I mean, those are actual rights and changes, and so they would be impacted, and that would not be allowed. So there are ripples from this that might make this harder and harder to implement. We're just going to have to see. But this, and I'm also going to have to see, because this is, who wrote this? This isn't, I have a really bad feeling that this is, oh, it's Barrett. Okay, well, we'll see. Okay, we'll see. Because if it was, I just read that Gorsuch opinion yesterday that was just really, never mind. Oh, I'm kind of surprised they let her write that. That's a big one for her. Anyway, whatever. Good on her. I mean, that's good. Big opinion for her, early on in her career. Anyway, yeah. So that's why I am hesitant to say where these are going to fall out. I think this is going to have to play out. Could they roll back that the injunction could be brought back if this is brought up again? Yeah, maybe. So the budget bill limiting injunctions is already dead. I am very surprised that Roberts didn't take CASA. The what do you call it? The parliamentarian knocked down I think I looked that up yesterday, and I'm pretty sure that's what it said, that the parliamentarian knocked that down. That was very much in line with the bird bath. So I'm pretty sure that was one of the ones that got knocked down. I think I saw that. House Bill 1549. I don't know what that one is, unless that's the one that's in Paxton. And guys, you don't overread the Trump immunity ruling. It doesn't mean what you think it means. The Trump immunity ruling is far more limited than people believe. He doesn't understand it clearly, because I heard him talking about it the other day, or he's trying to assert it in the they're trying to assert it in the E. Jean Carroll case. So he does not have any idea what that case means. It is incredibly limited. The president must faithfully execute the laws of Congress. In executing those laws, he may not be held criminally responsible for his actions while executing those laws. That's where he is immune. That's it. This lower court nationwide ruling is a good thing. No, not a good thing. No, one way or another, it's not a good thing. But because, well, and again, I usually stick out of these things, but the problem that I have with it, even when I don't like the outcome, is that if the court holds that a policy or a government action is illegal, violates the Constitution, allowing it to continue, how can they allow it to continue? That doesn't make sense. And one of the things that, an injunction is supposed to stop irreversible harm. There's another word, but basically that. And one of the definitions of irreversible harm is having your constitutional rights violated. You can't. That is one of the things. If you're losing money, that is never irreversible harm, because money can always be repaid. If this is costing me $100 a day, then the people on the other side, at the end, I can sue them for that $100 a day. That is never irreversible harm. Irreversible is not the right word. I just can't think of the right word. Irreparable harm. There we go. Irreparable harm. But having your constitutional rights violated for a minute is considered irreparable harm. So if a plaintiff is having their constitutional rights violated, then that's irreparable harm. But just because someone is not a plaintiff doesn't mean other people aren't always also having aren't also being irreparably harmed. So I'm not sure how this works unless AGs start joining all of these cases on behalf of their constituents. Every single one of these cases, which is going to be a lot of work for AGs, I guess. I don't know. Yeah, this was used against Biden for student loans, and I wasn't thrilled with that outcome, but that's what the courts do. Frivolous lawsuits are a funny word. Frivolous lawsuits. I have a whole thing about frivolous lawsuits. They are not as easy as you think, and we have a whole rule that can get you disbarred for filing frivolous lawsuits. So if you're filing them pro se, that might be a frivolous lawsuit. If there's an attorney involved, it's probably not frivolous. Yeah, you can get disbarred. We have a rule. It's actually a signature rule. It's a rule about signing your name on something. I believe it's Rule 11, Rule 8, Rule 11, something like that. if I put my signature on a court document, I am, according to the rules of whatever, I am affirming that I believe that this document is, the legal arguments in this document are sound. And that this is based on a good legal argument. And if I know that it is not, I can be disbarred. So truly frivolous lawsuits, not as common as you think. What you're gonna hear a lot, and I keep seeing these ads that are running right now, there is always a running narrative about tort reform. Tort reform is about limiting the number of people, and by people I mean, let's say, citizens, consumers, human beings who walk into stores, who can sue stores, businesses, dare I say corporations, when they are harmed in some way. So tort reform is usually a euphemism for profit protection. So whenever you hear somebody talk about tort reform, it's those ads, those commercials, those are paid for by some sort of business interest trying to convince people to protect their profit margins or insurance rates or something like that. Always, 100% of the time. Same thing with whenever you hear, I'm sorry guys, you are not going to like this. Some of you are not going to like this. But if you ever hear anyone talk about regulations, most regulatory, red tape, regulations, all of that stuff, 90% of regulations make it more difficult for huge profit centers to slightly raise their profits. And that's because of Dodge v. Ford Motor Company. It's a case from 1918 and it requires every corporation that has public stockholders to make all decisions in favor of their public stockholders. They have to make every decision in favor of public stockholders, which means every decision has to be made in favor of profit by law. The only way that they are excused from that is by a regulation. A government regulation, if it comes down to, do we spend 3 cents for the non-recyclable garbage bag or 4 cents for the recyclable garbage bag, we have to buy the 3-cent one because it is cheaper and it slightly increases the profit margins for our shareholders. Unless, well, there's 2 exceptions actually, unless we can use the fact that we're using the recycled ones to raise our profits through advertising, for example, or there's a regulation, a government regulation in place that says we have to do that. So that's Dodge v. Ford Motor Company. So anyway, that's what regulations usually are, the main source of producing things. What are my credentials? I'm an attorney. I was Assistant Attorney General, Chief of the Civil Division for American Samoa. I used to be assistant to bankruptcy trustee. I've been an attorney for 13 years. I've done a lot of different stuff. The reason that it's never been challenged is it's actually good law. It is actually good law. People who put money in as uninterested investors, people who buy stocks. You go to E-Trade and buy 1 $10 stock. The agreement, I mean, you are just putting your money in that hole, right? You have no control over the company. You have very little decision-making power there. They make all the decisions. And so the agreement is, I'm putting my money in this big black box. You guys have to try to make it into more money. You're not allowed to just flush it down the toilet or, go to Vegas with it. You have to try to make more money with it if I'm going to just put it in there and trust you guys to do good stuff with it. And so that's where that rule comes from, is that if we're going to allow people to just blindly put their money into a black box in the stock market, then the people who run those companies have to have a fiduciary responsibility to those people to do everything they can to try to increase the value of those stocks. So it is good law, unfortunately. But the only legal caveat to it is government regulation. So anyway, hear about DOJ whistleblower. I did see some of that. I have to go look into it more. I've been really busy. Good podcast about American civics. I don't know of any. I don't know. Oh, and by the way, there was a movement for a little while to create another style of business where you would go in with the agreement that your profits would be secondary to a mission. And they were trying to get this set up. They never quite figured out how to make that work with the IRS. And so it never took off. It was like in the mid 2010, 2012, something like that. But they never quite got it off the ground. I don't have any recommendations for American Civics podcast because, I was just talking about this, I work on this all day until my brain starts to rot. And when I'm not working on this and not reading about this, I want to think about anything else. This thing starts to hurt. And so I don't listen or watch, like I get little bits and clips from people, but I don't listen to like long form stuff because my head starts to hurt. That type of business model was called it's like an E34 or E43. Hold on, I can tell you in a second, maybe. L3C, that was the name of it. A mutually beneficial low profit limited liability company, low profit limited liability company, L3C. And that was the goal. The idea was that it would have as part of its business model not maximizing profit. And as long as people went in there with their eyes open, yes, I am putting my investment in here and I understand that you are not going to maximize my profit. That was okay. Thank you very much for sending me grocery money. Thank you. It's keeping me alive. Do I do any public speaking gigs? I haven't. I feel like I should. I've only been doing this for about 6 months. Exactly like this. And I just haven't figured out how yet. Nobody's asked me. So, and I also need to like take some time and work out some like longer form stuff. And I don't know how much you guys know about like the way that TikTok works, but in order to like keep in the FYP, you have to post and post and post and post and post. Some people's videos are just like, hey, I'm walking down the street, things are fun, woo! My videos, the particularly the longer ones, could take me 8 or 10 hours between, reading, shooting, editing, and or sometimes longer, and trying to get a few of those out a day. Just it's killing me. So and so I'm still kind of behind. So I haven't gotten to a point where I can afford to like take a day or two off and work on something else. Like occasionally I take a day or two off because I have just hit a wall and cannot go any further, but not to work on stuff because I just haven't been able to. So hopefully that will change. I am finally kind of getting stuff together a little bit. Hey Ted J, how you doing? Okay, explaining the rule limiting judges. Okay, so all I have so far is that I don't know enough. You know, I've been talking since it came out. I probably could have read through it by now. I apologize. Oh, actually, hold on. I'll come back and do that again in 1 second. But I need another from the class here. Let's do... I don't think I'm going to read my mood detailer. I just don't think it's going to be interesting enough. But who do we have? We have Paxton. We have Casa. Braidwood is going to be the other important one. So I got green and yellow left. What do you guys think? Green or yellow for Braidwood? What was the massive tome you showed us on the Constitution? I will show you in a second. So I need to just decide what color I'm making Braidwood. Anybody? Green, yellow? Green? I'm seeing it so far. I've just seen green, so that's probably where we're going. Green. All right. So 1 yellow, 2 green, green, green. I don't have a wood green. I just have whatever that is. But all right, I'll do green. Let's see here. Let's see, 86 pages. So we're going to start with pages 1 and 2. And then through 86. In 1 sec, I will be right back over there. Two-sided, double-sided on the short side. And 110%, so it's slightly more readable. There we go. All right. Oh, I saw some questions. So the book that I showed you guys. Hold on, let me go grab it and I'll show it to you. Over here. Ooh, heavy. So this right here is the Constitution. This is my copy of the Constitution. What is that printer? Oh, this is my, I don't know. It's printer, laser printer. So, this is a really big Constitution, and it is put out by I think the Congressional Research Service. Let's see if I can show you. I know everything's in reverse, but so it's Constitution of the United States, Analysis and Interpretation. This is the Centennial Edition. Analysis of cases decided by the Supreme Court, prepared by the Congressional Research Service of the Library of Congress. And I still haven't finished applying for that job. I really need to do it, but I'll give you another update on the SCOTUS in just a minute. I'll go through this again. But this basically goes through every section of the Constitution and gives you kind of a quick rundown of all of the case law on every section, one by one. And actually, it does even a little bit more, because it does sort of a like a descriptive paragraph, and then underneath it cites the case law. So it is really awesome. I actually have 2 of these. I have one from 1986, and this one's from 2012 or 1973, something like that. I have not applied for that finished applying for that other job yet. I've been working on it. Yeah, I think you can buy it on probably from the GPO, the Government Printing Office. I don't know. I inherited it. Had someone who died who got it from. I used to work at an office with a lot of former bigwig Congress people. Actually, one of them, who was a very good friend of mine and passed away, used to be the Republican Chief of Staff for the House Appropriations Committee, and was one of the nicest guys I have ever met. It is the Constitution of the United States of America, Analysis and Interpretation by the Congressional Research Service. And yeah, it's, okay, so gpo.gov/Constitution annotated. They may even have an online version, because they're not really trying to make money off I mean, they're definitely selling it for money, but they're probably offering an online version too. Oh yeah, I have a giant bookshelf downstairs. It's just full. I have so many law books, but I still buy them because I still read them because I'm an idiot. I don't know. Okay, let me run through cases real fast. I'm going to try to do this as quickly as possible. Okay, so I'm going to go Trump v. Casa is the big one. And it was not about, even though everybody thinks, even though everybody says it's about birthright citizenship, it's not. It's about the ability of lower courts to enjoin the federal government. I need to read it because I'm not clear on what the language says. Generally, the stays that were requested by the federal government are granted. So those injunctions that were granted by the lower court have been limited to, potentially anyway, again, I need to read that one in detail before I answer this very well. But it looks like they have been limited to just the plaintiffs, but exactly what that means, I'm not sure yet, because limiting them to the plaintiffs could mean a lot of things. The damage to the plaintiffs could be broader than we realize. I need to read that one in detail. Kennedy v. Braidwood, again, is one that I need to read in more detail and be sure about. The question was whether or not members of this particular board need to go through the congressional approval process when they're appointed. The decision was no, they do not. They are inferior officers and can just be appointed. But the bigger issue has to do with, and I'm not sure how this plays out in the end once that decision is made, whether or not it somehow has to do with whether or not HIV meds are available, not HIV meds, HIV preventative meds are available in the case of religious exemptions. And I don't know how those two are connected yet. I can make a guess, but until I read it closely, I won't have a great answer on that. So give me time. FCC v. Consumer Research. This organization wanted to limit or shut down this government program that provided they provided high-speed internet service in rural areas, and this organization who fights woke corporations wanted to shut them down. They said that this program violated the non-delegation doctrine, and the court said no, it does not. So that will still continue. Universal Connectivity Fund, I believe, yes, that's it. Mahmoud v. Taylor is about in Montgomery County, just outside of DC, there were there was a story hour that had LGBTQ themes in it, and parents wanted to take their children out of it. There was no exemption option, and the court said there has to be an exemption option for religious reasons. And finally, the age verification on Pornhub, which originally was decided based on rational basis, which means it was not given First Amendment treatment, has been raised to intermediate scrutiny, which means it was given First Amendment treatment, but it was not given strict scrutiny, which is the highest level, but it passed intermediate scrutiny. So that is the answer. It's still allowed, but it was given a higher level of scrutiny. So it's at least treated as a First Amendment issue. Okay, so that is the quick run through. By the way, once again, right here, all of these cases are here in my shared documents. You can also support me a bunch of different ways here if you want to keep me doing this stuff. I really, really appreciate it. You can subscribe here too, but there are a bunch of other ways that you can follow me on the YT, which I can't say the name of. Future birthright citizenship, we know nothing more about today. That did not change anything today. Everybody kept saying it was going to. That was not what that case was about. So don't worry about that yet. Let's see. Yeah. So go here and you can download all of these cases. It's in the. If you go into my shared documents into June 27th, SCOTUS things, they'll be in there. And if I end up having to download any other case law or statutes or anything in order to make any videos, I'll put them in there too. Because I will be making more videos. Sotomayor's dissent was a blast furnace. On which one? All right, so we have Braidwood. Oh, injunctions. Okay, I haven't been able to read it yet because I've been here. I'm gonna go soon. Got one more to print, and we are down to the last color. So this one's gonna be yellow. Which one are we doing? We're gonna do FCC because that is the non-delegation doctrine one, which again I'm really excited about. I don't expect that many people to be excited about it, but I probably won't get to it for a few days. Unless I get tired. And it's an easier read. I don't know. That's FCC v. Consumer Research. I'm probably not going to do Mahmood. Who knows? I might change my mind. If that's the one everybody's talking about, maybe I'll do Mahmood. But I don't think it's going to be... somebody just said... Oh, I really love non-delegation. So, only SCOTUS has the ability to block it across the country now, unless a class action. Yeah. Or I would like to see if... So my other question, and this is the part of the problem, is that with... I've worked as an AG, and AAG, and we represent... AAGs are often the only... person, for lack of a better word, the only entity with the power, with the standing to bring certain cases on behalf of residents of a state. And so what I would wonder in a lot of these cases is, do we just have to start adding, 50 plus AGs to every one of these cases in order to make it a class action on behalf of the whole country? So, I don't know. That's what I'm wondering. Can a state sue on behalf of its people as the AG? And in a lot of cases, I would imagine yes. But maybe not. I've got to read this. So, they didn't touch the state standing issue. So, yeah. I would see if that's how this ends up shaking out. That's going to make this extremely... Oh, you're right. Yeah. But more than 30 AGs. That's a good point. But I don't know. Well, we'll see. 3296. Sorry, I'm just getting this last case ready. And 2 pages per sheet to make my eyes hurt. Get a little bigger to make my eyes hurt slightly less. Ooh, that's another long case. We got a lot of case law today. And this is kind of the end. Yeah, I'm a little bit surprised as well, but do you need a portable page magnifier? No. Actually, so these glasses are more for farther away than they are for close-up. I'm actually pretty good close-up. This actually came while I was in American Samoa. I fell and hit my head very hard. I slipped on I was out hiking and I slipped and fell, and it kind of knocked my vision off, and so I've had to wear these glasses ever since. But it's more for things that are far away. Yeah, TBI. But it's more for farther away, but which stinks because I have had perfect vision my whole life. Perfect vision. And it took away my perfect vision. And it took me a while to figure out that that's what was going on, because I'd had perfect vision my whole life. Yeah, I have a lot of stories. I don't even know where to start. What do you think about their statement on allowing lower courts to assess requirements? I don't know yet because I'm going to have to do a really full read on that. I'll tell you what, guys. Okay, so one more thing. I'm going to do this one more time only because this might be the last time I have a big group in front of me right now. Download the videos. If you want to help me, please do. You can subscribe here. There are other places to follow me because you never know how long the TT is going to be around. So there's YT and a couple other options. What I'm thinking I'm going to do is maybe try to come by a little bit later and maybe do another live either later today or tomorrow and break down where things are going once I've had some chance to read. Even though I'm going to do a more formal breakdown video, maybe do another live too. I've kind of had fun with these, and we're not going to have any more of the cases. So, yeah. So I think I might do that while they're fresh over maybe over the course of this weekend. But I do want to stop and get some reading done, so that I can actually answer some of these questions rather than just doing this. Guessing they're going to have to keep coming back to this case. Probably, yeah. I think that this case and what was the big one yesterday? Medina, I think are both going to have some big implications long term. So we'll see. And you also, there's we'll see. And I did get, somebody did call me out, by the way, for giving a very blatant more policy-based or more interpretational-based opinion in my Medina video yesterday, and they were quite right. I did fully step into a judge's robe for a minute because I felt that there was an argument that was being overlooked and that needed to be considered, which I don't frequently do. But there were so many things in the Medina opinion that gave me pause, and most of them the things that gave me pause because they were said and I didn't like them, I went ahead and thank you very much, Wolf of the Air. Thank you. The things that were said that I was like, I went ahead and said them and said, well, this was questionable, but okay, I'm not a judge. But the thing that wasn't said is the one that I felt I needed to add. So I did take a step. Give us the Bryan opinion and attorney opinion. Thank you. I as a general rule, I want to teach as much as I can, and what I think is, hey, that's cool, isn't always teaching. So that's why I do try to keep that a little bit limited. But there were a lot of things. Like there was one thing in here that I want to, that just has been sitting weird with me. One of the kind of underpinnings of this decision was that the Constitution charges the executive branch with enforcing federal law. And that was one of the kind of underpinnings of this. Whoa, that was cool. And I was like, and I went and looked at it, and the Constitution charges the president with faithfully executing the law, not enforcing the law. And okay. So there were kind of some things in there where I was like, all right. But anyway, yeah. Oh yeah. No, I'm not gonna lie to you. I may take a while to give you the full answer, but yeah, no, I'm not gonna lie to you. I don't think so. No, I'm never going to lie to you as long as lie requires intent. I might misspeak sometimes. I may have to retract something every now and again. Hello. Who is childless meowlennial? Because I'm guessing this is somebody who actually knows me in real life. I think we've wandered into. So yeah, that's my goal right now. We have all of these. All these guys are ready. Wow, there's a lot of paper from today. What rulings came down today? It was everything. Everything came down except for Calais, which is going to be pushed to the next thingy. To the next term. That's the word. So 239 from the GPO. Okay, that's not actually terrible for the size of that book. That is that book doubles as a building material. It is big. Are we doomed? We are not doomed. We are not doomed. So I promise we are not doomed. I don't promise that we will never be doomed. That I can't promise, but sorry. But I promise that we are not doomed. Oh, and somebody who said Aloha Friday. Yeah, I working in Samoa, I got used to wearing these shirts, so and it is fun. I'm trying to figure out if no room on my shelves. Fair enough. I'm trying to figure out though if it's Elise. Oh my gosh, it's Elise. Okay. Elise, one of my friends, used to be my neighbor in San Diego, is on here. I'm here for the fashion first, and the lawn says, hey, I appreciate that, and thank you. I think that I rather bring the fashion, right? But that's very exciting. Elise is here. I want my own island, no tariffs. I will tell you, after living on an island without, like, Target or Target's just an example, but any kind of a regularly stocked store, it's harder than it looks. And I there was a point where I thought of myself as very rugged and able to survive relatively well. And it might just be my old age, but it was a lot tougher than I thought. Part of that might also have been the number of hours I was working, so I wasn't able, I didn't have time to go out and find, it's not like there were, what do you call it, there were coconuts and there were other things that I could have gone out and found, but I was working crazy. I was working until I, eventually slipped and fell and cracked my head open. So I was working crazy hours. And so I barely had time to get to the very few stores that we had. And we even had to be careful about which stores we went to, because some of them were safe to go to, and some of them we were told, like, don't buy meat at this store, don't go to this store, get milk, So I definitely was not as prepared as I thought I would be. And I'm a little, I'm a little traumatized. Thank you, Joey. All right, guys, I'm going to wrap up, at least for now. I might come back later and do another live once I've gotten some reading done, but let me at least catch up, get some of this reading done, tell you what's going on. All I could do there was drink. Yes, and for the record, I was not drinking when I fell and cracked my head open. Oh, wait, real fast before, because I see Joey, that was Joey who said that? No, wait, hold on. Joey, shoot me a message, and let me talk to you a little later. If you send me a DM. Did you read the limitations on injunctive relief yet? I haven't read them yet. I've kind of skimmed because I've been on here ever since. So I'm going to go take a break, read. I will be preparing regular videos, and I may do another live just to at least catch you guys up on what I'm seeing before I try putting together something formal with edits and, because that takes a long time. I don't know if you guys noticed, but, I finished that live yesterday around noon, and I didn't get I only got 2 more videos done all day. One was at 4 and one was at 7:30 or something. So it takes a while to get these things shot and edited. Partially because I'm not very fast at it. But I do my best. All right. Thanks a lot, guys. And I will see you all later. Elise, I'm glad you made it on here. It was good to see you here. And I will go eat lunch, I promise. All right. Thank you, guys. I will see you all soon. And you can go download the cases. And you can look at them yourself. And then we'll talk about them in a little bit. They're in the shared documents. So, okay. Bye.